of meaning. So in Singapore, having adopted the model law in 2017, we have recognized foreign insolvency proceedings from the US, from Australia, just as examples. And more topical for today's purposes, in 2020, the Singapore High Court recognized a liquidation order from the Nanjing Bankruptcy Court as a foreign main proceeding. So that's the first. And I think in terms of how the recognition process will work, I think between Singapore and mainland China in future, I think this case is seen as a positive development, because I think in terms of proceedings involving potentially Singapore and mainland China, because the mainland Chinese regime looks at reciprocity. So this decision by the Singapore High Court is seen as a step in a positive direction. Now, under the common law in Malaysia, which still is using the common law, English law-based reasoning when it comes to recognition application, the Malaysian courts look at the place of incorporation of the debtor company primarily in the past, but I think increasingly there's a trend to look towards the COMI of the debtor company, or the center of main interest. Because I think, as Justice Harris mentioned, as well as Yuhan also alluded to, that the place of incorporation being given primacy is a conventional concept. It's been there in English law for centuries. But I think the increasing recognition is that even though a debtor company may be incorporated in a particular jurisdiction, the nerve center, or the place where the decisions are made, for example, may not be that place of incorporation. It may well be just incorporated there for whatever reasons, but the center of main interest is somewhere else. So the common law has also increasingly recognized the importance of the COMI, and the Malaysian courts in recent years as well has used that as a reference point in determining whether and to what extent the Malaysian court should grant assistance or recognition of a foreign insolvency proceeding. And very recently, just this month, the Malaysian and Singapore courts have announced a court-to-court communication protocol. And for those who are familiar with the Judicial Insolvency Network, or the JIN, the Malaysia-Singapore court-to-court protocol does have some elements of the JIN guidelines in terms of promoting and facilitating communication between the courts of Singapore and Malaysia in certain types of cross-border cases, shipping, admiralty cases, and of course, cross-border insolvency cases.